Hi, everyone. Welcome. We're going to let folks roll in and then get started. We'll give it to about 11:02. Okay, I know I am still watching the numbers tick up, but we've got a lot of information to cover. So I want to get us started at least somewhat on time. Welcome, everyone, and thank you for joining us today. We are so pleased as NCBC to present challenges in statutes of limitations for child sex abuse. We can tell this is a hugely important topic to everyone right now, just given the number of registrants we have today. My name is Renee Williams. I'm the Executive Director of the National Center for Victims of Crime. And before we get started, I know at this point we're all really used to these webinars right now. We've lived with them for 2 years, but I want to just give a few ground rules that NCBC follows. We go ahead and leave the chat open so everybody can communicate with each other. And I think that that's really brought some invaluable communication in the victim services world. But any questions that you have really need to be placed in that Q&A box for us to answer them. I'm going to take questions if they are timely and pose them to our presenters if it's something that's in that moment, but most of the questions we are going to save into the end, and we will save about 15 to 20 minutes at the end. At the end of this, we will be posting this on our YouTube channel, and it will also be available online. If you miss it, we will also have it transcribed, so there will be closed captions at the end. With that, it is my absolute pleasure to introduce our esteemed presenters, Marcy Hamilton of Child USA. Marcy is a Fels Institute of Government Professor of Practice. She is also the founder, CEO, and academic director of Child USA, which is dedicated to interdisciplinary evidence-based research to prevent child abuse and neglect. Marcy is the leading expert on child sex abuse statutes of limitations and has submitted to testimony and advised legislatures in every single state where there's been significant reform. So we are so lucky to have her with us today to be sharing her thoughts on what's going on and how we can make it work better. We also have Jason Amela of Fow, Cochran, Vertitas, and Amela. The majority of Jason's work is on behalf of survivors and child sex abuse survivors. He is based out of Seattle, Washington, where he helps people who have been severely injured and need an attorney and a law firm who can really navigate these very complex cases. We are incredibly fortunate to have them both with us. They are absolutely the leading thought leaders in this field. And with that, I'm going to turn it over to Marcy.
So thanks so much, Renee, and thanks everybody for taking some time today to talk about, or I guess to listen about and then talk about child sex abuse statute of limitations reform, or SOL reform as it's been coined from years ago. This is really a vibrant movement at this point. It started relatively slowly in 2003 in California with a 1-year window. But we now have a tremendous amount of activity. And just so you know, for the lawyers who don't know, I know a lot of you do use our materials, but we do 2 primary things with respect to statutes of limitations. Well, I guess we do about 10, but the 2 big ones for you are that we track the movement in child sex abuse statutes of limitations on a weekly basis. By every Friday, every week, we have updated whether or not it's a bill pending, a bill passed, maybe it's gone through committee, so you can stay up to date through our 2022 SOL tracker, which we have every year. We also track the history back to 2002 of every state. So that comes out in an annual history report, and the 2021 report will come out sometime toward the end of May. So let's just start with the next slide, please, Cameron. So to give you a sense of what's going on is, and as you can see quickly from this graphic, the statute of limitations reform has moved much faster on the criminal side than it has on the civil side, but these numbers show a tremendous activity in the last 10 years, the last 7 to 8 years. So, but let me point out, there's a lot left to do. We work on it. And of course, our sister organization, Child US Advocacy, advocates for change in every state. But we also are working now in the federal system. So, and I'll explain that. So, but note that the 49 states that have no criminal SOL, that's for some or all child sex abuse crimes. There are states that have just blanked it. And there is no criminal SOL, but then there are states where they have chosen specific child-related crimes, and those are the ones that have no criminal SOL. What's difficult in the criminal context is that once your SOL expires on the criminal side, the Supreme Court has said that's an ex post facto issue. You can't revive it. So the ex post facto clause says you may not revive a criminal statute of limitations. So all of the changes and the approaches that we're making in the states on the criminal side are all prospective. That's just a constitutional limitation. But on, we do, however, have much more latitude with the civil side. So we have worked very hard to get these two next data points down, or up, I should say. We have worked, there are about 17 states that now have no SOL on the civil side, and about 27 that have some form of revival, whether it's revival up to an age, like Connecticut, or it is revival that goes backwards and forwards, like Vermont and Maine, and everything in between. And this is a movement that is not only national. We're also seeing some interesting developments in particular cities. And I am now co-chairing the International Task Force for SOL Reform, because numerous survivors from around the world, of course, are asking about this access to justice. So this is a global movement, and we are staying very focused, of course, on the states. Cameron, please, next slide. So I put this up for the main reason of explaining that we rank the states on SOLs. We rank their civil SOL, their criminal SOLs, and also we have a joint ranking of all SOLs. And you can find all of this on our website, childusa.org. But I just wanted to highlight the worst and the best. So right now, if you're looking at the question of just the civil side, the worst states, and some of you I'm sure know this, are Alabama, Indiana, Maryland, Mississippi, North Dakota, Ohio, and South Dakota. These are really tough nuts to crack, but we're actually working on several of those right now. We're kind of amazed. There's even a discussion right now in Alabama, no offense to our Alabama attorneys, but there's lots to be done there. The best areas are the first entity, or I guess we should say territory, that adopted a backwards and forwards window is Guam. And you might be interested to know why, how is it Guam that led the way? Well, Guam actually passed a 2-year window before that. And what happened? Nobody came forward, not one person in Guam. And so they went back and they just said, there are no more statutes of limitations with respect to civil claims in Guam. And that's where all the lawsuits came from that you're seeing now in the settlements and the bankruptcy going on. So Guam is good. Louisiana is one of the best states. You might have predicted that a state so heavily controlled and influenced by the Catholic Church would have been on the last rung. But Catherine Robb and a number of the attorneys in Louisiana really made a difference. And so we're thrilled that Louisiana is one of the best. Maine, Minnesota, New Jersey, the Northern Marianas Islands, and Vermont. And I am now working on a list of the territories I need to investigate for SOLs and sunshine, but we're always open to donations from Marcy traveling to nice places. But anyway, so next slide, please. So this is a map of what's going on right now. And essentially you can see the permanently open windows up in Vermont and Maine. The yellow are the age caps where it's revival, but it only goes up to a certain age. And the stripes have a window and an age cap. So, you know, and that's New Jersey, but we update and release these kinds of images to help everyone understand what's the play, what's going on right now in the United States to see where the activity is.
Marcy, you do have a question that's important for right now. Can you just explain briefly what a revival law is?
Oh, I'm sorry. So there are two options here. One is that you can eliminate the statute of limitations, which is just this ordinary deadline. It's just a deadline for filing a suit. But you can either, when you go to the state legislature, ask for them to extend it or eliminate it going forward. That will help every child being abused right now into the future. Or you can ask the state to revive the expired SOLs for the victims from the past. About 20 years ago, many of the states had a limit of 2 years after the date of the act. So a 6-year-old would have had up to age 8. And then many states moved to 18 plus 2 years, 20 years. But as the science has become more and more refined, and we're really working extremely hard on delayed discovery issues, you know, the average age is late 40s, early 50s to come forward. So the vast majority of victims have been silenced by expired SOLs. A revival literally revives their statute of limitations, and they go forward with the ordinary case. Next slide, please. So this is just an image, and here is a QR code if you want to pull up the SOL tracker to see how much is going on. But you can also go to the homepage of childusa.org. It's always near the top. And when you're trying to quickly figure out what's the SOL, that is where to look originally. And then, of course, we have a 50-state map. And you can look at each of these states individually and figure out where you stand. We also, our legal department, it does answer questions. And so if it looks like something's either odd or not quite right, or you have a question about one of the SOLs, don't hesitate to reach out to us because this is what we do. Next slide, please. And that's just another image of where the tracker is. So let me get into reform bills. Next slide, please. So this year we are branching out from the states into the federal government, but at the same time, New York City has enacted its own window, raising thoughts and opportunities for being able to do this in other large cities. This one has already passed. It only applies to abuse in New York City, but child sex abuse in New York City will have a new window. And it goes in, the law itself goes into effect in September. It's already been signed and sealed, but doesn't go into effect until September. But cases cannot be filed until the window opens in March of 23. So I always get a lot of pushback on, wow, lawyers are just overburdened in the states with windows. Here you go. You get some time before this new window opens, but this is going to be very expansive because it's going to be applicable to children and adults. The bill, the law itself, if you look at it, is about gender motivated violence, but there is a significant line of cases in New York that expands that to include child sex abuse and adults for sex abuse and sex assault. So this is a possibility. If you have a client who was abused in the city of New York City, regardless of their age now, they're going to be able to come forward. And if you also have a client who was assaulted as an adult, this revival window will work for them. So that's a really exciting development and a new arena for victims to come forward. Next slide, please. I just talked about New York, but Florida has also passed a bill already this year, which it will eliminate the criminal SOL for an adult using or promoting a child in a sexual performance. And this is an interesting development that's worth knowing about. What happens is in these SOL bills, we try to include every crime that we can possibly come up with that should be covered. But this is incremental. And so sometimes there will be a crime that's not included. Florida, just having eliminated the criminal SOL in a lot of contexts, just added sexual performance to it. So that's why it's always useful to check up and see what's the latest in your cases, because we have a lot of activity really on a weekly and monthly basis. Next slide, please. So here is what's going on this year. We have a total of 28 states in the federal government that are considering. The one that's been passed is New York City, but the others are considering 9 would eliminate criminal, 9 to extend the criminal, 17 to eliminate the civil, 11 to extend the civil, 16 for a window or revival, which is to say there was a time when it was a lot more relaxing, because the only window up for discussion was, for example, the Delaware window, which was open from 2007 to 2009. We're now to the point that the activity is intense, and we welcome all of you. If you're in a state with things happening, please feel free to reach out to us. We are working with a number of grassroots organizations in the states, and we always welcome survivors who are ready and capable of sharing their stories in the states where we are working on the SOL. So next slide, please. Now, we've expanded this year to talk about the federal SOL possibilities. You know, here's the issue. The SOL for federal law was eliminated in some categories already, but the question is, can the federal government do anything with respect to the state SOLs? And because of the Constitution being so annoying, and dual sovereignty and federalism, the federal government cannot possibly mandate to the states that they change their criminal and civil statutes of limitations. It's simply not an option. But what the federal government can do is to incentivize the states. In other words, use the purse to persuade the states to do a better job. And we have several different bills that are pending both in the Senate and the House, which would do just that. The first one that was introduced was Jennifer Wexton's bill in the House. She's in Virginia, and it would incentivize the states by creating more funding for them through CAPTA, the Child Abuse Prevention and Treatment Act money. And so this is something that the federal government does all the time. It gives some money to the states and makes sure they do something better. So we love this idea. We actually drafted this bill, but right now, excuse me, it's pending in part because of a few other things happening in the world. So we hope to get more attention retrained toward this after the Supreme Court nomination goes through, we hope, I hope. And of course, Ukraine issues settle down a bit. So, but we're working on it. We're talking to these members every day. Please forward. Cameron, please forward the slide. Okay. Now there's another bill, and these two slides, the next two slides are identical in one sense. It's the same bill, it's different houses. So Representative Gwen Moore from Wisconsin has been terrific on these issues. She is very highly motivated, and she has introduced with Senator Gillibrand a bill, No Time Limit for Justice Act. Again, it would eliminate the criminal and civil SOLs. It does not incentivize windows though, but it would provide a meaningful increase in funding if they eliminate prospectively criminal and civil SOLs. Those dollars are taken from crime prevention funds as opposed to to CAPTA. Next slide, please. And this is the same bill. We can go to the next slide. The other bill that's out there is for a federal law. 18 USC section 2255 provides for lawsuits involving sex offenses against minors, child sex abuse, sex trafficking, online exploitation, child sexual abuse material. We did succeed in getting a discovery rule into that provision. But we are now, we've got active consideration by Senator Durbin, who has bipartisan support that would eliminate the statute of limitations for 2255. So 4 cases that you could plead a federal claim. This is something well worth looking into. And it's not a huge slice of federal law, but we're just going to keep pushing out the SOLs across state and federal law. Next slide, please. So let me just close by saying the other arena that we are really interested in is federal bankruptcy reform for child sex abuse victims. So that's for another webinar, but of interest, I think, to many of the practitioners. And thank you very much, Renee.
Thank you, Marcy. You did have 2 questions that I think we'll take now. One was, have you seen any data on district attorney offices following through with the prosecution of these old cases? Or is there data on the actual convictions?
It's rare. And it's very rare. And there are 2 reasons it's so rare. The first one is that for the prosecution, you need to prove beyond a reasonable doubt. Prosecutors like to win and will not enthusiastically go after claims that are considerably older, unless they have a string of survivors coming to the more recent past. So you know, it's a possibility, but it's hard. The other issue is, you know, the statute of limitations in the vast majority of states on the criminal side expired well before most of the victims come forward. If you have a victim come forward in a state, though, like Wyoming or Maine, where there's no criminal SOL, those are the ones where there's an option. And that's where you really do have to make a pitch to the district attorney that the evidence is there.
Thank you. So we have lots more questions, but I think those we're going to save to turn it over to Jason. And Cameron, can you pull Jason's slides up? Uh-oh.
Did we lose Cameron?
I don't think so, because he took the screen down. But actually, while we're waiting for him to do that, these are questions that both of you can answer, and we'll do that now. Oh, no, we won't. Jason, the floor is yours.
Hey, all right. Good morning, everyone. My name is Jason Amela. As Renee said, I practice out of Seattle, Washington. I want to start by apologizing to Renee and Cameron and to all of you for being on my phone. I am holed up in my co-counsel's office in New Brunswick, New Jersey, because we were ordered to attend the Camden bankruptcy mediation yesterday. So the tech issues are mine. I found out this morning that my video camera is not working on my laptop. So fun times. Anyway, so thanks for the opportunity to chat with everyone this morning. This is a really big topic, so I'm going to hit the high levels, but please, my contact information is on this slide. Renee knows how to get a hold of me. And if you have any questions at all, really happy to take all the time in the world to follow up with you. Cameron, could you do the next slide, please? So just a quick overview. I'm going to talk very briefly about my background so you understand where I come from on these issues. Talk about the types of statutes of limitations, and then give some advice on at least how we approach client intake with regard to statute limitations, particularly when talking with a client where it's unlikely that their claim can be pursued right now because of the statute. So my background, just very briefly, we're based in Washington State. As Renee said, 99% of my practice and most of our Seattle office's practice right now is representing child abuse survivors. And it dovetails with this presentation today. Washington State in the mid-90s was one of the first states in the country to reform its statute of limitations, specifically for survivors of childhood sexual abuse. So when the Boston scandal broke in the early 2000s, people came forward around the country, and Washington was one of the only states at the time where they really could come forward, file a civil lawsuit, and move forward. So that is how our firm got so experienced in this area. As other states changed their laws, largely due to the work of Marcy and Child USA, we're often brought in to help pursue the cases there because we've had a lot of experience. Really, just because our statute of limitations it was so liberal when a lot of this really started after the Boston scandal broke. Cameron, could you do the next slide, please? So I'm going to talk about types of statute of limitations. I'm going to try really hard not to talk very much about specific states for what's up on the screen now, which is biggest advice I can give you is retain local counsel, talk with a lawyer who knows how to pursue these types of cases and who understands both the state you're working in's statute of limitations, and there is no one size fits all with statutes of limitations. And you also get into things like statutes of repose, all sorts of other issues that pop up when you're counseling a client on the statute of limitations. So again, I'm going to try to give a 30,000-foot view, but best advice I can give today is speak with lawyers who actually know the law at issue. Cameron, the next slide, please. So for types of statutes of limitations, I'm going to go through each of these. But the first is the traditional statute of limitations. And in most states, it's, a negligence claim is usually what you're looking at. If you're pursuing, I should be clear, I'm going to largely talk about claims against not the perpetrators, but the claims against institutions that enabled or allowed the abuse. So in most states, traditional tort, negligence statute of limitations is 2 to 3 years. If you're talking about something that happens to a child, I think in the vast majority of states, the statute is told until they turn 18. Some states, I'm shocked to find out, actually don't toll the statute until you turn majority. But I think in the vast majority of states, it starts when you turn 18. But as Marcy said, that traditionally gives you 2 to 3 years to bring a claim. And, we'll talk a little bit about why that's problematic. And then I'm going to walk through these other slides, these other types of statutes. So Cameron, can you do the next slide, please? I wanted to put this in there. This is a slide that I stole from Marcy and Child USA. But when we talk about these different types of statutes of limitations and why reform is so important, I think this slide sums up one of the major themes that you'll see and why you need reform. And that's the fact that, most kids don't tell when they're children. And if you don't tell, then you're obviously, not pursuing a claim as a child. And and I'm going to simplify here, but as Marcy said earlier, it's trending now. The average age for people to come forward is in the late 40s, early 50s. 10 years ago, when I would give a similar presentation, I would tell people the average age of our clients was around 57, 58. And so it's great to see that number is trending younger for a lot of reasons, including all the reform that's happened. People are coming forward earlier. The Me Too movement. There's a lot of reasons people are coming forward earlier, but the fact remains most kids don't tell, and most people don't come forward until later in life. And so when you look at these different statutes, you're seeing either the legislation or Marcy's efforts or the courts trying to fashion remedies to address the fact that kids don't tell. And I'm going to really simplify it, but the way I usually explain to people is kids don't tell. Then when they turn 18 and they're in their 20s, the last thing they're focused on is revisiting a childhood trauma. And historically, we wouldn't see someone coming forward till they're in their 40s or 50s because they, on some level, start to look back and deal with what happened to them as children. A lot of times they don't realize they were injured or the extent of the injuries they suffered. So that's, I think, what you see in these statutes we're trying to address. Cameron, can you do the next slide, please? So the first we call connect the dots. That's a term of art. I don't know if Marcy uses that or what term she uses, but when we talk about connect the dots, what we mean is when a survivor begins to understand how the abuse affected them. And that's some of the states that have reformed. We'll talk more about window states, but the idea is to acknowledge that survivors don't really meaningfully understand how the abuse affected them until later in life. I would say the vast, vast majority of our cases are not repressed memory. And by that term, I mean someone who truly doesn't remember it at all. And then suddenly the memory comes back one day. That's not very many cases in our experience. That's not the vast majority of survivors. Most survivors remember the abuse. They just don't want to try not to think about it. And in turn, they're not trying to think about how it affected them. They a lot of defense mechanisms. I'm fine. It didn't affect me. They just don't want to think about it. And they don't want to think about how it harmed them. So the connect the dots statutes essentially give survivors a certain amount of time from when they begin to understand, to connect the dots between the abuse and their injuries. What does that mean? And this is why I said there's no one size fits all. I am way overly simplifying a very complex issue right now, so please don't hold that against me. I'm not trying to be insensitive to the nuances here, and they're important. They're not nuances, but they're important differences. But what does that mean to understand how the abuse affected you? I think a really good example is New Mexico. Marcy can jump in and correct me if I'm wrong, but I believe in New Mexico, the statute they reformed in 2017 gives survivors 3 years from when they'd first disclosed the abuse to a counselor or a therapist. So that's one way to look at when does someone begin to understand how it affected them. You get the idea. You tell a counselor about the abuse. On some level, you're acknowledging maybe there's an issue there. That's pretty unfair when you compare that to the Washington state statute of limitations, which is on the screen right now. And that's our statute. Our statute and how the courts have interpreted it is to say you have 3 years from when you begin to understand the causal connection between abuse and your more severe psychological injuries. What does that mean? Right? How our courts have interpreted it is to say most survivors remember the abuse. Most survivors feel guilty. There's the common guilty, ashamed, might have nightmares. Our courts have said that's not enough to start the statute of limitations. You need more. And really what our courts in Washington have said is the plaintiff, the survivor, has to subjectively understand really what about the abuse has caused their psychological injuries and more severe psychological injuries. So for example, someone might think maybe I have a drinking problem because of the abuse. Maybe they do, but that's not really the causal connection, right? Maybe they have anxiety or depression that causes them to drink. Even then, that's not actually what's going on. And again, I'm simplifying here, going on. it's really the trust issues and other issues that arise from the abuse that causes anxiety, depression, and then causes the drinking. So our statute says it's not until the plaintiff actually understands that level of connection that their statute starts. So that is, I think, a really good example of a connect the dots state that tries to get it right in Washington State versus somewhere like New Mexico, which says, well, just because you disclose the abuse to a counselor, that may mean nothing. I have plenty of clients who disclose the abuse to a counselor and don't begin to really understand the connection until years later. Cameron, can you go to the next one, please? The next type is discovery rule, and sort of similar to connect the dots, but what a discovery rule really focuses on is when does the survivor discover either that someone was at fault for allowing the abuse to happen, or discovers that they've been injured. You know, there are a lot of survivors who just simply don't appreciate or understand that they were abused. They don't understand that they were harmed. And so discovery rule states focus on, you know, when does the light bulb go on? And they go, wow, that was an abusive relationship. You know, fairly common in Catholic cases with priests. They don't realize that that it was abuse. They just don't connect the, I want to say connect the dots again. And they don't realize they were damaged. So a little similar to connect the dots, but that was historically the way that we early on tried to get around statute of limitations, was to basically show people it's discovery rule. They didn't discover or realize that they had a claim. And again, it can also be focused on a liability when you finally realize that the Catholic Church puts out its files and the plaintiff goes, oh my God, I did not realize that my diocese or my parish kept this priest around after getting complaints. So it's when you discover that the third party is actually liable for what happened to you. Cameron, can you do the next slide? Oh, I'm sorry. I had one in here I missed and I left out. I had an example earlier that I was going to give you of why these discovery rule statutes are so difficult. And I did want to point out, again, no one size fits all. Discovery rule states you can also have objective versus subjective standards. So is it when the plaintiff actually reads the secret file and knows what the diocese did wrong, or the Boy Scouts did wrong, or the defendant did wrong? Or is it when a reasonable person would have investigated and figured it out? So again, all these statutes vary state by state. There is no one size fits all. And that's, again, why I suggest you always want to talk to local counsel and people who've kicked the tires on these statutes. The next type of statute is the window legislation. And the first of these, well, I'm not going down this path, especially with Marcia on this, I'll probably get it wrong, but a window legislation essentially gives survivors a certain amount of time, a window to bring a claim. And so in great examples, what happened in the last few years, New York opened the Child Victims Act. That was a 1-year window that was then extended to 2 years. So all survivors, regardless of their age, had 1 year to bring a claim. Again, it got extended to 2 years. It's closed now. New Jersey followed suit with 2-year window. So all survivors, regardless of their age, had 2 years to bring a claim. And then California, that window is still open. Survivors in California have 3 years, regardless of their age, to bring a claim. So, and the California window closes at the end of this year. So that's window legislation. You can have pure window, which is this, certain amount of time for people to come forward, regardless of their age. And then oftentimes, I shouldn't say often because there's not a lot of these, but I think there's an effort to couple that with, once the window closes, putting in some sort of discovery rule that allows people to come forward within a certain amount of time of, again, connecting the dots or discovering the liability or their damages. Cameron, could you do the next slide, please? Hey, Renee, how am I doing on time? I lost our start time.
You're doing amazing. You got about 5 minutes.
Okay, good.
Maybe 10, because I'm feeling generous.
All right. You're only saying amazing because we've got a big audience. It's not what she says behind closed doors. All right. So talk a little bit about tolling. And what tolling is, the work that Marcy and Child USA does is, reforming the statute of limitations, to give survivors more time to come forward. Tolling is in some states that haven't reformed their statute, or if they have, it still may be on the books, but in states that haven't reformed their statute of limitations, sometimes courts have created tolling mechanisms or acknowledge tolling to pause the statute of limitations for certain reasons. So, sorry to not articulate that very well, but what you have are courts. I'll give you a good example. In medical malpractice cases, if you go in for a surgery and 20 years ago, and you come out of the surgery, you think you're fine. 20 years later, your stomach starts to hurt. And yeah, that's weird. And they take an x-ray and there's a sponge in you. They say, have you ever had surgery? Well, yeah, 20 years ago. You didn't realize until 20 years later when the x-ray shows the sponge that someone committed malpractice. They left a sponge in you. You didn't start to be harmed until your stomach started to hurt 20 years later. That is tolling, right? And in those cases, in most states, you have 3 years from when you discover they left a sponge in you. You discovered the injury, you discovered the liability to bring the claim. And so this is very related to the discovery rule that we talked about in statutes. What you see are states codified in their statutes this same concept that was more of a common law discovery rule. And so, again, you can do this legislatively, or you can do it by common law by judges saying, hey, you know what, for these child sex abuse cases, on some level, it's akin to this example I just gave you with the doctor, to say, hey, if you don't realize until you're 50, you don't find out that the church kept a bad guy around or the defendant kept a bad guy around. On some level, that's the same as discovering the sponge 20 years later. And similarly, the harm. If you don't realize until 20 years later that you were harmed, why shouldn't your statute start at that point? So that's discovery rule. Fraudulent concealment is another way to toll the statute of limitations. And again, some states recognize these concepts, some don't. But fraudulent concealment is normally when a defendant conceals their wrongdoing. So using my example of the sponge, if there's a doctor's, the nurse notes, does the count, says, man, doctor, we had 20 sponges to start. We only have 19, and the patient's already been sewn back up, and they just kind of move on. That's would be fraudulent concealment, because the doctor, the nurse have an affirmative duty to tell the patient, hey, we committed, malpractice, just like us lawyers have an affirmative obligation to disclose our malpractice. So in fraudulent concealment cases, it's usually the defendant conceals their wrongdoing from the plaintiff, doesn't disclose it to them. And that's the idea is if you hide what you did from the plaintiff, you shouldn't be able to hide what you've done for 3 years and then later say, aha, you didn't bring your claim in time. So that's fraudulent concealment. And then last is repressed memory. And in some states, when you have survivors who repress the memory and don't recover the memory until much later in life, some states have acknowledged that also is another way to toll the statute of limitations, and they give you a certain amount of time from when you recover the memory. I put other on there because again, every state is different, but I think there are some states where things like if the defendant paid for your counseling or gave you some sort of benefit, that can toll the statute of limitations. And I'm not going to pretend to know the nuances of those laws because we don't have in Washington, and I don't know them very well. But it's another reason why I emphasize the importance of retaining local counsel and or talking to lawyers who practice in this area. One of the things that we see is for states that haven't caught up yet through the work of Marcy and Child USA and haven't changed their statute, there's different ways to approach these issues. And in a lot of states, the work hasn't been done yet just because people haven't come forward like they have now or more recently. So always good to talk with lots of people to get ideas about how to approach these issues. Cameron, can you do the next slide, please? Major issue. This is like have Marcy on speed dial. Is the statute of limitations reform retroactive? And people get caught up on this all the time. States sometimes change their statutes, but it is prospective only. And so you don't want to get in a situation where you read a statute and go, wow, my state reformed its statute recently, my client's good to go. In a lot of states, they've changed their statutes limitations prospectively, so only going forward, simplifying here, but the change only applies to people whose statute hasn't yet lapsed. And during the Q&A, Marcy can probably give some examples, but really, really important is you got to look at the statute and then dig in and find out if my client's statute of limitations previously lapsed before the statute was reformed, is it retroactive? I hope that makes sense, but people get caught up on that all the time, and if you don't want to lead prospective clients astray by thinking their claim's timely, telling them that you think it's timely, and then suddenly find out you were very, very wrong. Cameron, next slide, please. So just want to close by sharing some thoughts about how we advise clients on the statute of limitations, particularly if it looks like their claim's not timely under the current law of their state. As I mentioned a minute ago, even if you think the claim is timely, I would not from the start, unless you know for sure it's timely. Like I even in Washington, I know the law pretty dang well. Window states, you would know that they're probably timely, but I would make sure you're on very solid footing before you start telling clients, hey, you're good to go, your claim is timely. I would almost always say, hey, we need to look hard at the statute of limitations, and make sure you're on solid footing. But focusing on clients when their claim's likely not timely, some advice is when you're kind of sharing the unfortunate news, is we like to tell folks, look, the law of your state just hasn't caught up yet, and it's antiquated, and it needs to be reformed. The trend is to reform the statute, and it's not about them. It's not their fault. The abuse isn't their fault, and if their claim isn't currently timely, it's not because anything they've done wrong. It's not because of the merits of their case. It's literally just because their law hasn't caught up yet, and that's why I mentioned the recent statute of limitations reform. 5 years ago, New York was a shutdown state. Today, there's Marcy, 10,000-ish cases in New York that are all viable. So these things can happen very quickly. None of us saw Arkansas changing, and boom, Arkansas changed. So maybe Marcy did, but the rest of us didn't. Something else is very, very important. Some states that haven't reformed their statute yet, there may be ways to get around the statute through these tolling mechanisms like fraudulent concealment. Those oftentimes are very difficult. Saying there's a good fraudulent concealment case is an oxymoron. It's very hard, and the facts you need are generally, you need a really good facts. I'm going to keep it at that. But one of the things you have to consider is, should a client roll the dice and try to pursue fraudulent concealment or try to get around the statute, and risk having a claim dismissed? Because sometimes if your claim's dismissed and then your state reforms its statute, if your claim was already thrown out once before dismissed, you can't get a second bite at the apple. Sometimes you can't, and Marcy can speak more to that. But that's a big question: is do you roll the dice and try to get around the statute now, risk having your case dismissed, and then if your state does change later, you can't avail yourself of the change, or do you wait and see if the reform happens? Something else that's really important, if it comes to the point where you're advising the client that their claim's just not timely now, is talking about other options. Filing a police report, talking to a counselor, other options that they have, filing a complaint with the defendant, the institution that did wrong, something that allows them to make a choice and take other action than just filing a civil lawsuit. And then the last two things Marcy asked me to address is, what do you do with like a bankruptcy where Boy Scouts we just had? You've got a lot of people whose claims are timely, and you may represent people whose claims are untimely. What do you do in those situations? And what we are very clear about, my advice there is to be upfront and honest with your clients. And if they're in a situation like a bankruptcy where they have to come forward, is being upfront. Your claim may have statute change, and this is, again, I'm simplifying, but you've got challenges, and your claim may not be timely, but being really upfront during the intake process and not glossing over this issue, and acknowledging that, you represent other people whose claims may be timely, and you have to have your joint representation agreement because of the ethical issues in doing that. But it's really important because a lot of lawyers are getting involved in this area, a lot of marketing, a lot of people signing up, just whoever calls them, without giving this type of advice up front. And it sets everyone up for failure and frustration. And then the last thing is to memorialize in writing when you talk with people about these issues and the statute of limitations, because statutes change. And we've had, I hate to say this, but we've had people who've called us up years later and said, hey, what's going on with my case? Because the statute changes and it's a case that we had to decline. And we're like, we didn't agree to represent you. Yeah, you did. Yeah, you did. And I see the law changed. And, thankfully, we've always been very good about memorializing, when we've had to tell people that their claim isn't timely, and being very clear that we do not represent them, but that they should call us if the law changes. So, Cameron, is there one more slide, or I think that might be it? There we go. Renee, did I do all right?
You did perfect. I just came on to sarcastically tell you were out of time, but I didn't mean to if you were done. Thank you, Jason. Thank you, Marcy. So we do have quite a few questions, but I did want to walk everybody through something first, because a lot of the questions are very specific about what is the law in my state. And so I did type out some answers to some folks, but I'm actually going to show everyone specifically. Cameron, can you unshare Jason's screen so that I can share? To answer all your questions, if I type the answer out, I actually went to Marcy's page. And so we will do a quick tutorial. If you type in Child USA into your log and you go to law and you click on law, you can click on any one of these states. I will pick Maryland because it's where I currently am. And you can see the statutes of limitations, the age of majority, age of consent, and age of marriage, and mandatory reporting. Any law that you could possibly want to know that deals specifically with child sex abuse will be right here. Now let's stop sharing. The other frequent question was, how can I find this webinar? I did pop in the link in the chat, but the easiest way is just to go to YouTube. And we have two channels, the National Crime Victim Bar Association and the National Center for Victims of Crime. If you type in either one of those, they are both YouTube channels, and this will be on both as soon as we upload them. Now, Marcy, can you explain CAPTA a little more? That was the most general I could ask.
So there's a federal statute that provides grants to the states, and CAPTA is the short name, but it's about child abuse prevention. And so the states get a certain amount if they're engaging in activities that have been directed by the federal government, that the federal government would like to see. So what's going on through CAPTA with SOLs is that the federal government, we hope, will say and pass into law a bill that says of the money that you get from CAPTA, you will get this much more money if you improve your statutes of limitations by either eliminating them, civil or criminal, or by passing a window. So it's a big chunk of money that goes to the states.
Thank you, Jason. This one is for you, and I'm going to combine a whole bunch of questions in one. First of all, does it matter if you reach out to a lawyer where the survivor currently lives, or should you reach out to counsel in the state where the crimes happened? And then what could threatening and harassing behavior toll the statute of limitations as fraudulent concealment, or is that state by state?
So the first question, the statute of limitations that will apply where the person currently lives is not going to be the relevant statute of limitations. It will be either, generally speaking, where the abuse happened, or sometimes it's it's where the negligence took place. So, for example, if I'm the Christian Brothers of Ireland and I am in New York and my provincial council meets and sends a bad guy out to Mississippi, arguably, you can try to argue that the statute of limitations of New York applies because the negligent decision making happened in New York. Normally, oftentimes it'll be the statute of limitations of where the abuse happened. But I just want to flag that sometimes it can be one or the other. And then again, the law varies. Thanks, Renee, for packing in. Yes, the law varies by state on what fraudulent concealment is. I will say generally harassing by itself would not be concealment. Normally concealment is, you go and ask, you say, hey, this happened. And they say, oh man, boy, never heard anything about this guy. That's shocking to hear. Or, hey, did this happen to me? Did it happen to anyone else? And they lie about it. So it's every state is different. Some states, they actually have to proactively tell you if they know that they messed up and hurt you, or allowed you to be hurt. Generally speaking, claims against institution, harassing wouldn't be by itself wouldn't be enough, but obviously you can harass someone at the same time you're lying to them. So I want to be clear about that, right? Like, oh gosh, why would you? We never knew anything about Father Jones, and man, why would you possibly raise this? Boy, that type of stuff.
And this question is state specific, but I'm actually going to ask it in a different way so that it's applicable to everyone. What's the best way, and this is for both of you, what's the best way someone can find a support and healing group? Do you know of any great sites or resources off the top of your head that people can automatically go to that will lead them to a national, and I'm thinking like SNAP, but any others that would lead them to a very good support group?
Our advice, and then Jason probably knows more than I do on this question, but our advice is that every single survivor who's considering coming forward needs a therapist, a personal therapist. The problem is that every claim and every set of suffering is radically different for each individual. So they need their own therapist. There is a resource online where they can learn about child sex abuse, and that's the Hamilton Library on our website. And so if they're looking for information, we're encouraging lawyers, send them to the library. That will give them an opportunity to learn safely. But with respect to organizations, there's Male Survivor, there's SNAP. Are there others, Jason, that you send people to?
They used to go by Shepherds. I forget the name now in Seattle. They are focused on childhood sex abuse. If you called them and asked for referrals, that's what I would do. That's what we tell clients often. But I think we oftentimes go to the experts we really like and trust and ask them. But I hate to say that. I'm going to stop there. I don't want to speak ill of anyone out there that's trying to do the right thing. It's just very, very tough. And
we really need to grow the therapist pool. And part of that is our educating them. And so that's definitely on the, things to do agenda for us, because it is frustrating. We get calls all the time. Now, Male Survivor is starting a referral service for therapists for male survivors. For female survivors, there's a real need, and that's one of the things we're looking into.
And hey, Marcy, hey, I'm sorry, just really quick, just because there's so many, I think, providers and professionals on this. There's a lot of chat going on right now. Yes, for sure. Trauma groups that help people who've gone through trauma, not just child sex abuse. Those are good starting points for sure. So I hope nothing and again, I just want to say we had an hour today. These are very difficult issues, and we generalize tremendously. So I hope we didn't say anything offensive, and definitely not trying to. These are really complex issues.
And frankly, all of you on today, please send me your contact info, because you're clearly tuned in, and we get calls from all over the country all the time looking for the therapist that's right for the person.
That is all the time we have. I want to thank you both so much. I know you've both been watching the chat, so everyone is very appreciative. Many, many thanks to you both. And thank you everyone for joining us. Again, these will be posted pretty quickly to our YouTube page, and keep an eye out for more webinars like this. Thank you.
Thanks so much.
Thanks, everyone.